asset protection. If you make the IRA beneficiary an IRA trust, you're not actually transferring the IRA into the IRA trust, it's already a trust. IRAs are trusts. But you're saying that any payments from this have to go to the trust as the beneficiary, designating a third party as the trustee, not the kid. Then you will have asset protection. Now you can do that in your revocable trust just by creating what's called an accumulation trust, an accumulation distribution trust. So you can say in your revocable trust, if the IRA pays it to it, that I want the trustee to hold on to the distributions from the IRA. But if you do that, it's going to be taxable within 5 years of the date of death. And so you lose the income tax benefits if you use an accumulation trust. You don't have to do it for the entire thing either. You can break the IRA into pieces. You can preserve some of it and have it taxed. You can force distributions through required minimum distributions for another part of it. It's all done through beneficiary designations that are attached or submitted to the IRA administrator, to the trust administrator. So the key benefits of an IRA stretch trust or an IRA trust is the ability to stretch out the distributions over the life expectancy of the IRA beneficiary. That's an income tax planning benefit. It gives asset protection for the IRA beneficiaries. And with the U.S. Supreme Court case in Clark versus Ramekin, as I talked about in a prior session, it gives creditor protection, even in bankruptcy, if this asset is payable to an IRA trust. Whereas IRAs that are inherited are not protected in bankruptcy. Remember that from before? I don't know if you were with me before when we talked about that. And of course, it gives you the opportunity as the financial advisor for continued wealth management as opposed to busting the IRA and spending it on Ferraris.
Wayne, are the distributions taxed at trust rates or do they flow through the individual?
That's a great question. So if the trust is accumulating the distribution, it's going to be taxed at trust rates. If the trust is distributing the distribution, it'll be taxed at the beneficiary's individual ordinary income rates. Any other questions on IRA trusts? All right, special needs trusts, another niche planning strategy. We've done a lot of them here. My partner, Catherine Schott-Murray, is an elder law specialist, and she does more than probably anyone in this firm. We have 8 estate planning lawyers here at this law firm, and she really has done a significant amount of work with special needs trusts. So if you ever need help with this, give us a call and we'll connect you with Catherine, and she's really, really good at helping you design the trust. I've done them too. What is a special needs trust? A special needs trust is an important place, estate planning tool, that supplements government benefits. So if you're permanently and completely disabled, you may qualify for certain benefits, including Medicaid, SSDI, disability income, and certain other benefits given at the state level, depending on the state. Virginia's not very generous, but Maryland is, and DC is, and Pennsylvania is. Other states have more generous state benefits that are available to people who are disabled. So if you have a child who is disabled and you set up a special needs trust and they qualify for government benefits, this trust, if properly structured and properly drafted and properly administered, will preserve those benefits for the beneficiary, and it'll also protect the assets in the trust from the claims of the state or the federal government. It's providing supplemental care. Now, it's actually much broader than you might imagine in terms of the types of care that a special needs trust can provide. And clearly, if you have a child or a relative that you want to leave assets to who do qualify for these benefits or may qualify for these benefits, including a mental disability. You do not want to leave the asset directly or outright to that person, because if you do that, it clearly will disqualify them from the ability to receive these government benefits. But it's also not necessarily in their best interest to do that, is it? You leave something to a child who's suffering from bipolar disorder, and they get an inheritance of $500,000. What are they going to do with it? So if you leave it in trust, it's a better way of planning for this, and a special needs trust, if they qualify for governmental benefits, will protect it from a clawback or claim by the federal government or state government. So there are two types of trusts that we create that are special needs trusts. We might create one while you're alive, so you contribute assets to a special needs or supplemental needs trust today, and it's for the benefit of that individual who is suffering from the disability. Or you might create a testamentary special needs trust. It's either done through a will or a revocable trust. We usually put it into our revocable trusts for clients who need this. First thing we do is we create an advisory board. Who's on the advisory board? We'll cover this. We want to name an advocate, the person who's aggressively pursuing the interests on behalf of the beneficiary. We want to select the trustee of the trust, somebody who's managing the assets and making the disbursements in accordance with the trust provisions. This is a little different. In a special needs trust, you do not, under any circumstance, want to make direct distributions of cash to the beneficiary. It could disqualify them from receiving the governmental benefits. So the trustee's job is a little more time intensive. They actually have to go out and purchase items and deliver it to the beneficiary, or give it to the caretaker to give to the beneficiary. And usually in a special needs trust, particularly for severely disabled individuals, we'll have a care manager, somebody who is in charge of planning for the care for the individual who is subject to the disability. Somebody who knows the disability, whether it's autism or Asperger's or Down syndrome or whatever the case may be, somebody who understands the disability, understands what types of care are needed for this individual to keep them happy and functional and thriving. How do we fund a special needs trust? Well, that's your job as the financial planners and the financial advisors, CPAs and insurance agents, people that really can help manage the money in this situation. How we fund it? Well, often we'll use a life insurance policy. In the old days, there were two ways that people handled these special needs children. One was to disinherit the child, which is not a good solution. And the other was the opposite direction, providing too much for the benefit of the special needs child and nothing for the rest of the family, which is also not necessarily the best way to do this. So particularly in estates where we only have a couple $1 million or a few $1 million, what do? Well, a common way of funding it is to use life insurance. We also want to actually create the special needs trust as a beneficiary in the revocable living trust. So I have 4 kids. I have one that's suffering from a disability. I leave 3 shares in a general trust for my 3 regular kids. And I leave a 4th in a special needs trust for the benefit of my disabled child. Those trusts are going to be very different in the way they function, in the way they read, and the way they operate. So life insurance we've often used as a common funding tool for these trusts, and I usually prefer to use a permanent life insurance policy because we want this life insurance there if something happens to us later on.